Good day, Crime Talk aficionados. We have a great show for you. First, Bryan Kohberger. There were so many signs. Lori Vallow, she's on the road again. Donna Adelson, well, she's beginning jury selection. A Georgia teen is accused of killing her mother and stepdad. Well, she's denied bail. We have this day in legal history, our quote of the day, and our dumb criminal. Let's talk about it.
All right, lawyer.
Good day, everyone. My name is Scott Reich, and this is Crime Talk. Thanks for joining us. You know the drill. Subscribe if you haven't. Like if you do. Leave me a comment below. Hit that little bell for notifications of when we go live or put up new content. And you can always check us out on any of your favorite podcasting apps. Speaking of going live, well, it's Tuesday, and we intend to go live tonight, 6 p.m. Mountain Time. We'll be answering your questions. Maybe we'll put up the call-in line, and we'll talk about what you would like to talk about. And if you don't call in or tell me what you want to talk about, well, we'll talk about what I want to talk about. And there's plenty to talk about indeed. So before we get to the docket, let me remind you to go to CrimeTalkSearch.com. Sign up for a background subscription today. When you do, you will be able to do as many searches as your heart desires as long as you have that subscription. But guess what? You can also cancel at any time. So whether you want to do 1 or you want to do 1,000, you can in fact do it. When you get that background search done, your results are emailed to you literally while you wait. And you're going to find out what this person has as far as phone numbers, emails, social media presence. You're going to find out information as to whether they're married. Are they divorced? Do they have a criminal history? Are they on one of those sex offender registries? That's right. Things that you want to find out about people coming into your life, or maybe someone you're not getting a warm, fuzzy feeling about, and you think maybe I need something to convince me that they need to get out of my life. Go to CrimeTalkSearch.com. You're going to be happy that you did. All right, ladies and gentlemen, more and more documents are coming out, and we're reviewing them as they come about from the Idaho State Police, Pullman, Washington, and unfortunately, the Moscow Police Department put a hold on theirs because one of the family members is suing and asking for an injunction that the crime scene photos not be turned over. But we can talk about that more tonight. All right, let's talk about Bryan Kohberger, right? More troubling conduct was revealed in unsealed documents and the digital forensic analysis. So unsealed court documents and digital forensic examinations have shed light on Bryan Kohberger's prior support for the death penalty, his interpersonal conflicts during his doctoral studies, and some unusual activities on his electronic devices. Now, Kohberger, who obviously entered a guilty plea, that's right, for all the people that think he's innocent, he entered a guilty plea to 4 counts of murder and a count of burglary as it relates to the death of the 4 University of Idaho students. And obviously that spared him capital punishment. A stance, coincidentally, that contrasts sharply with his earlier vocal endorsement of it. It's kind of like mandatory minimums, right? Everybody thinks they're great unless it's their family member. But hey, it is what it is. Anyway, during Kohberger's time as a criminal PhD student at Washington State University, Kohberger was the sole advocate for capital punishment in class discussions, according to some recently released records. He argued that families of victims should hold the authority to determine its application. Isn't that the pot calling the kettle black? In one instance, he illustrated his position by posing a hypothetical scenario to a female classmate, inquiring whether she would favor execution if her young daughter were subjected to a violent assault and homicide. Well, this exchange, documented in an investigative report, left the classmates, well, a little unsettled. The same individual reported feeling singled out by Kohberger, describing instances where he would corner her at workspace and dominate conversations with unconventional views and derogatory remarks. She also recounted observing his display insensitivity toward a student with a hearing impairment, questioning her suitability for parenthood due to her condition. When challenged on his conduct, Kohberger reportedly responded dismissively, acknowledging her feelings, but insisting on the correctness of his perspectives. We also know there were a lot of complaints. That's right. So Kohberger's behavior while a student and teaching assistant prompted widespread concern within the community there. Records indicate he accumulated not one, not two, not three, not four, not five, no, but 13 formal complaints within his initial 3 months in the program, dating back as far back as August of 2022, with many originating from female students and staff. Now, descriptions of his comments characterize them as discriminatory, encompassing bias related to gender, disability, nationality, and sexual orientation. One community member labeled him as self-absorbed and lacking compassion, noting his desire to dominate every discussion. In response, university administrators convened weekly meetings to address these issues and implemented mandatory training on discrimination for incoming doctoral candidates. And who says Bryan Kohberger can't bring about change? Anyway, while interviews and police confirmed these measures, it is uncertain whether Kohberger faced specific disciplinary actions prior to his arrest. Now, we do know that he was basically fired as a teaching assistant, but no other disciplinary actions as far as being expelled, obviously. And we're also getting more information as it relates to the digital forensics. So forensic analysis of Kohberger's cell phone and laptop conducted by experts from Celebrite uncovered patterns reminiscent of a narcissistic traits. Investigators noticed numerous self-portraits where he posed shirtless, flexing muscles in various angles, evoking comparisons to the self-obsessed protagonist in the film American Psycho. Now, these images taken privately and not shared suggested a fixation on his physical appearance. Further examination revealed that on Christmas night, approximately 1 month following the November 13th, 2022 slayings, Kohberger accessed and downloaded multiple articles on notorious serial offenders. His search history included terms like psychopath and inquiries about similar figures, though he had erased browsing data from mid-October through November of 2022, encompassing, coincidentally, the period surrounding the crimes. How many times have I said it, ladies and gentlemen? There are no coincidences in criminal law. So after media reports identified a vehicle matching Kohberger's as a potential lead, he researched car cleaning services and replacement options. Now, experts observed efforts to obscure his digital trail, including data deletion from his laptop, which eliminated potential insights into his motives. Now, despite these gaps, the recovered evidence highlighted minimal social interaction beyond communications with his parents and extensive consumption of online videos. Now, for those who didn't know, obviously Kohberger pled guilty last month to 4 counts of first-degree murder and that 1 count of burglary, receiving the life sentences, 4 of them consecutive without parole, plus the additional 10 years for the burglary. Now, the agreement precludes appeals or any sentence modification, and guess what? That's right. He's currently incarcerated in the maximum facility where he is in isolation at the Idaho Maximum Security Institution, where reports indicate he faces a little bit of derision from other inmates. Could you imagine that? You know, he complains that they're up at night, that they can't get along with others. He can't get along with others. They're complaining because, they want to keep him awake. Don't you hate that, Bryan? Somebody waking you up in the middle of the night. It's not like they're stabbing you to death or anything, right? At least you got the comfort and protection of your cell, unlike your victims. I would state that you probably agree with me, right, Mr. Kohberger? Anyway, these revelations underscore these inconsistencies between Kohberger's academic positions and, his legal strategy, while highlighting some behavioral patterns that alienated peers and raised some institutional alarms. It's going to keep coming out, ladies and gentlemen. We're going to find out even more when the court unseals these filings that were made under seal. And you are going to find out that the signs that this guy was a freak, wackadoo, dangerous killer are going to be so obvious. And the people that say, oh, he didn't do it, they should be embarrassed. They should be embarrassed. And don't get me wrong. I believe everybody's entitled to a zealous criminal defense. I absolutely do. And even if Bryan Kohberger wanted to go to trial, I would have supported that he should go to trial. Let the facts come out. I think he would have been convicted. And I think once the jury heard about the brutality, he would have been given the death penalty. but it's going to be obvious that this dude was not wired right. All right. I'm telling you, I've represented a lot of people. We can talk about it tonight on the live show. I represent a lot of people over the last 30 years that are just not wired right. And the signs are so obvious. And usually it's cowardness by some people not willing to come forward and say, this dude is dangerous. Fortunately, there were people at the Washington State University, Pullman, that called him out, and one of the instructors said, this guy's a freaking psychopath, and that he could be a danger to his students and others because he is such a psychopath. Hats off to that particular professor for realizing what and who Bryan Kohberger is. Next on the docket, Daybell Vallow. That's right, her Idaho encore. Back on the road again to familiar haunts. That's right. The prodigal prisoner returns. That's right, Daybell Vallow, fresh from her Arizona escapades where she collected not one, 2 life sentences for conspiring to orchestrate the untimely exits of her 4th husband, Charles Vallow, and her ex-nephew-in-law, Brandon Boudreaux, has been whisked back to the great state of Idaho. The Maricopa County Sheriff's Office confirmed early Monday morning that she was sent back on August 18th, complete with an escort that screamed VIP treatment. If VIP stands for very incarcerated person, perhaps. Anyway, she was extradited to Arizona back in November of 2023 to face those pesky conspiracy charges. Vallow did not disappoint. An April jury pinned her for plotting Vallow's demise, and by June, another panel added Boudreaux to her grim resume. Last month, she was handed those matching life terms, ensuring her calendar stays booked indefinitely. Of course, this isn't Vallow's first rodeo in the Gem State. She's already serving a life sentence there for her role in the tragic deaths of her children, Tylee Ryan and JJ Vallow, plus her 5th husband's ex-wife, Tammy Daybell. Now she's on the road again, cruising back to those oh-so-familiar prison confines where she'll while away her remaining days in a setting that equal parts nostalgic and eternal. Talk about a homecoming with no escape clause. Next on the docket, jury selection kicks off in the Donna Adelson case. So in a courtroom drama that's been simmering longer than a forgotten pot on the soup, jury selection has commenced for Donna Adelson, the matriarch accused of masterminding the 2014 demise of her ex-son-in-law, Dan Markle. Now, Markle met his untimely end via gunshot at the Tallahassee residence, succumbing the following day in hospital care. Now, Adelson faces charges of first-degree murder, along with solicitation and conspiracy to commit the deed. And with a whopping 300 souls summoned, the quest for 12 impartial jurors plus 3 alternates is projected to span 3 days. Though the judge harbors doubts, it might stretch to Thursday, while prosecutors play the optimists. And obviously, once the evidence begins, we intend to bring it to you. Now, certain segments of the jury selection process will remain veiled from broadcast, with visuals holding steady on a court steel until the proceedings resume. Now, Judge Everett opened the concise overtures outlining 5 rounds of juror interrogation. He anticipated the selection might linger until Thursday, but the state begs to differ on that particular timeline. A short intermission ensued as prospective jurors settled into their seats earlier today, and at an earlier preparatory session, Judge Everett detailed the plan. 50 candidates screened in the morning, another 50 post-lunch, building towards a pool of 100. The judge then probed the group with fundamentals, confirming their age, that they're over 18, that they reside in the county, full-time student status, or primary caregiver for tots under 6, because they can get excused. He laid out the pivotal questions for potential jurors. What are your existing thoughts on this particular case? From whence did you glean said intel in this particular case? Did this knowledge tilt you towards guilt or innocence as it relates to Miss Adelson, if you know about the case? And can you shelve those preconceptions, ignore external noise, and judge solely on the courtroom evidence? Fair play assured for everybody. any barrier to committing up to 3 weeks of your time as a potential juror. Well, the morning batch of 50 hopefuls underwent scrutiny, yielding 26 viable candidates, while 24 were politely shown the door. Each faced solo questions in a sequestered chamber, attended by the judge, legal teams, and, of course, Miss Adelson herself. The media was there, and they got rotational peeks into these little dialogues with the jurors. Inquiries delved into prior case awareness, commitment to evidence based on verdict, and balanced evaluation of both sides. The remaining 26 jurors were instructed to reconvene at the courthouse by 11 a.m. on Thursday. And the afternoon lot of 50 jurors arrived later this afternoon, and they too, once they're told to, if they survive the initial questioning, to return on Thursday as well. Like I said, we'll bring you the Adelson trial this coming week, and as the weeks come by, should be interesting. You know, it's alleged that she's the mastermind of this case, where her son and several of his acquaintances and murder for hire people have already pled guilty. It'd be interesting to see what the prosecution tries to do to show that she was involved. Maybe it's that consciousness of guilt where she was flying to Vietnam, I do believe, on a one-way ticket, just moments before she was nabbed off the airplane. I think they refer to that as consciousness of guilt. Next on the docket, a Georgia teenager, Sarah Grace Patrick, denied bail in her murder case involving her mother and stepfather. So today, the 17-year-old Sarah Grace Patrick appeared in the Carroll County Superior Court for a bond hearing related to charges of murdering her mother, Kristen Brock, who was only 41, and her stepfather, James Brock, who was 45. Now, this incident allegedly occurred on February 20th in the home in Carrollton, Georgia, which is approximately 45 miles west of Atlanta, where the victims were discovered with multiple gunshot wounds. Now, Patrick, who was arrested on July 9th following an investigation that reportedly uncovered substantial digital and physical evidence, well, now faces 2 counts of murder and 2 counts of aggravated assault. She has not yet entered a formal plea, but has maintained her innocence through statements from her attorney and her family members. Now, during the hearing before Judge Dustin Hightower, Miss Patrick initially appeared composed upon arrival, dressed in her prison-issued jumpsuit, and interacted with another inmate. However, her demeanor shifted as the proceedings advanced. Defense attorney Latoya Williams presented 6 witnesses and 8 character references to argue for Patrick's release on bond, emphasizing that she posed no flight risk and urging the court to uphold the presumption of innocence. Witnesses included Patrick's father's girlfriend, Caitlin O'Keefe, who described Patrick's grief-stricken behavior in the days following the shooting, noting instances of prolonged crying and no behavioral concerns. Prosecutors countered with testimony from the victims' relatives, including James Brock's sister, Kim Bowling, who delivered an emotional account of the family's loss. Bowling expressed ongoing distress over the circumstances of the deaths, highlighting the trauma inflicted on the victim's 5-year-old daughter, who discovered the bodies. She stated concerns about Patrick's potential release, citing perceived risks of violence and manipulation. After reviewing the evidence, the judge denied bail, determining that the state had sufficiently demonstrated grounds for detention. Now, Patrick reacted with visible emotion upon hearing the decision. Her biological father, Donnell Patrick, left the courtroom early in distress and received support from individuals wearing T-shirts expressing solidarity with her. Pro point, ladies and gentlemen. I don't care what side you're on. No T-shirts in court. Seriously, it's just tacky. All right? It's tacky. Anyway, in the interim period before her arrest, Patrick engaged in social media activity depicting her mourning, including posts about the deaths and outreach of online true crime communities for assistance in resolving the case. Supporters interpret this as a genuine grief, while investigators viewed it as inconsistent with the evidence. Now, court records also revealed a history of family discord, including a 2018 custody dispute between Patrick's parents, during which her father alleged substance abuse issues affecting child safety. Authorities have not disclosed the specific motives, and the relatives of the deceased have rejected suggesting linking the victim's past to the crimes. Now, Patrick remains in solitary confinement for safety reasons, with a provisional trial date set for January 5th of 2026. Well, you may say that's great, Scott, but what's the evidence? Well, let's give you both sides. Now, police cited a substantial volume of digital and physical evidence as the basis for Patrick's arrest, described by police as a mountain of incriminating material. In the months following the shooting, Patrick posted content on social media portraying grief, including contacting true crime creators on TikTok to seek help with solving the murders, which investigators found suspicious. Well, testimony from James Brock's sister, Kim Bowling, asserted that Patrick demonstrated the capability for extreme violence and manipulation and expressed fears for safety if Patrick were released. Now, Patrick's eulogy at the funeral raised suspicions among law enforcement and the victim's loved ones, who perceived it as inconsistent with genuine mourning. Now, the victims were shot while asleep, with Patrick present in the home. She called 911 after her half-sister discovered the bodies, but no immediate suspects were identified until evidence pointed to her. Now, what are the facts pointing towards innocence? Patrick has consistently denied the charges through her attorney and family, with her biological father and his girlfriend publicly affirming their belief in her innocence. And defense witnesses, including family, friends, and relatives, describe Patrick's post-incident behavior as indicative of genuine grief, such as uncontrollable sobbing and no disciplinary issues, while staying with supporters. Supporters, including her maternal grandmother, have actively professed her innocence, attending the hearings and forming groups of advocates on her behalf. Text messages purportedly from Patrick expressed gratitude for support and conveyed emotional distress, which her advocates present as evidence of her non-involvement. Now, the case involves a history of family conflict, including allegations of parental substance abuse during the custody battle, which Patrick's father had suggested may provide context unrelated to her guilt, though this remains contested. So we'll see how this one plays out, ladies and gentlemen. Being in the house, not necessarily indicative of murder. Curious to see what other physical evidence there is related to her, and the physical evidence, or the electronic evidence, digital evidence. And the digital evidence will also be interesting to see how that plays out. Obviously, if there's text on there, "I want to kill mom and stepdad," obviously that's bad news. I'm not saying there is, but if that is some of the mountain of evidence that the prosecutor would be thinking about, well, that would certainly be a good example of it. But just being at the scene of a crime is not necessarily indicative of being the murderer of two individuals. So obviously she's entitled to the presumption of innocence, and we will give it to her, and we'll see how this plays out. Obviously, everybody always thinks they're going to get out of custody when they're in custody on a murder charge. Really not the case. I mean, I'm trying to think in the last 10 years, I think I've had two people that had reasonable bonds on homicide cases. One, the case was so weak, but the judge set the bond at, I think, $75,000, which might as well have been $75 million because she had no money once she got done paying attorney's fees. So she sat in custody, and then ultimately, that's right, not guilty. You're welcome. Next on the docket, this day in legal history, beginning on August 19th, in 1692, execution in the Salem witch trials. That's right, 5 individuals: George Jacobs, Martha Carrier, George Burroughs, John Proctor, and John Willard were hanged in Massachusetts Bay Colony following convictions for witchcraft, highlighting flaws in the colonial legal process and other due process concerns at the time. Next, 1791, Benjamin Banneker's letter to Thomas Jefferson. That's right, the free African-American astronomer Benjamin Banneker wrote to then Secretary of State Thomas Jefferson, and he challenged slavery and advocated for equal rights, influencing early civil rights discourse and citing the Declaration of Independence for his opinion. Obviously, it shaped Thomas Jefferson's views as well. Then on August 19th, 1917, arrest for violating the blue laws. That's right, ladies and gentlemen. It's a gateway crime. New York Giants manager John McGraw and Cincinnati Reds manager Christy Matherson were arrested for holding a Sunday benefit baseball game at the Polo Grounds, violating New York's blue laws prohibiting work or entertainment on the Sabbath. Like I said, it's a gateway crime. Next thing you know, they'll be selling cars on Sunday and selling liquor. Who knows where it'll go? It'll be chaos. Dogs and cats will be friends. You never know where it'll end. On this date, August 19th, 1958. The NAA poses a sit-in at segregated lunch counters. That's right. The NAACP Youth Council began a sit-in at the whites-only lunch counter of Katz Drugstore in Oklahoma City, a key civil rights protest that contributed to desegregation efforts and tested Jim Crow laws. On this date in 1995, Shannon Faulkner's departure from the Citadel. That's right. After a successful federal court battle to become the first woman admitted to the Citadel Military Academy there in Charleston, South Carolina, Shannon Faulkner withdrew after just 5 days due to harassment advancing gender equality in education under Title IX precedents. Now, of course, obviously, other women went on to not only get admitted to the Citadel, which was primarily an all-male school. Little known fact, most people at the Citadel don't go on to a military career, but it's like the holy grail, so to speak, in business in South Carolina. It's rather interesting. I've known several people that have went there, graduated. My experience, all been top shelf individuals indeed. In fact, one of the gentlemen that I knew when I was stationed down in Parris Island, South Carolina, was the first Black Regimental Corps of Cadets commander, or whatever they called it. And so every time I go to South Carolina, I always try to swing by the Citadel, drive by. Looks like a castle, kind of cool. Next, our legal quote of the day, a little pertinent legal quote addressing a witness's testimony that is so flawed, the court finds it incredible as a matter of law. And we cite to the case of People v. Catherns, 17 AD 2nd, 387, 1991. In that decision, the court articulated the standards as follows. A trial court may not reverse a conviction based on the weight of the evidence, but it may set aside the verdict if the testimonial evidence was so contradictory and so insufficient that a rational jury could not have found in any way that the elements of the offense were proved beyond a reasonable doubt. Now, I bring you that quote, ladies and gentlemen, because a judge can find a witness incredible as a matter of law. Recently had a situation where we got to cross-examine somebody, and let's just say incredible as a matter of law. Everybody thinks it's so easy to be a lawyer, and that's why cross-examination is one of the greatest tools ever created. Somebody can say anything, and then you ask them to, well, let's how you see how you're going to back that one up. Well, it doesn't always work. And you should be found incredible as a matter of law if you're lying, and the punishment should fit accordingly. Finally, our dumb criminal of the day. A former Connecticut state trooper, is it? Catherine Kopel. So in a striking case that underscores the principle that no one is above the law, not even those sworn to uphold it, former Connecticut State Police Trooper Catherine Kopel has been designated as our Dumb Criminal of the Day winner. What exacerbates the situation is that this individual, now a former law enforcement official, engaged in conduct that directly contradicts the integrity expected of her profession. As the adage suggests, it appears everyone is capable of dishonesty. Well, how did we get here? Well, on August 14th of 2025, the Police Officer Standards and Training Post Council took some action and decertified Sergeant Kopel, permanently barring her from serving as a law enforcement officer in the great state of Connecticut. Now, this decision follows a series of events that was reported in the news back in 2022. What happened? Well, Kopel, then a sergeant, was off duty but driving her state police cruiser when she rear-ended another vehicle twice and subsequently fled the scene. In an attempt to conceal her actions, she contacted the state police barracks and falsely reported that she had struck a deer. However, a quick examination of the damage to her police car revealed inconsistencies with a door collision, exposing her lies. Anyway, an internal investigation led to her termination. She faced misdemeanor charges for evading responsibility, aka lying, which were dismissed in 2023 upon her completion of a diversionary program for first-time offenders. Now, during the post-hearing on Thursday, Kopel had intended to address the council but opted not to upon learning that the news media was recording the proceedings. Her attorney stated afterwards that Kopel acknowledges her error and accepts her firing. though she had hoped to pursue other opportunities in law enforcement, a field that she has long aspired to. Anyway, this incident serves as a cautionary example of how poor judgment and falsehoods can irrevocably damage a career, particularly when you're dedicated to public service. Hey, and just because I am a criminal defense attorney doesn't mean I don't like police officers. I love police officers. I love good police officers, but we can't have the bad ones. And guess what? If they're willing to lie about something that they should have just accepted responsibility for, it makes you wonder, what else would they lie about in the course of their on-duty functions as a police officer? Something to think about. Anyway, it's culpable. You are a dumb criminal of the day. Congratulations, you made that. You can put that on your resume when you try to explain that you were fired for dishonesty. Good luck with that. All right, that's all we have for today, ladies and gentlemen. Thanks for watching. We'll see you next time on Crime Talk. And remember, the Constitution matters.